Okay, it just happened. The Supreme Court just ruled that Donald Trump can stay on the ballot. This is a big deal. This has to do with the Colorado case, and it also was followed by Illinois kicking Trump off the ballot. We got to break all of this down quickly. Before we go into this, I want to give you the breakdown of what to expect. Before this ruling came out, we were looking at 8 different things. I broke all of this down on ehack.com. There were 8 things we were looking for as to whether or not I thought Donald Trump would actually end up staying on the ballot. And you know me, I try my best to be as unbiased as possible. And so the 8 different reasons that we thought that Donald Trump was probably going to stay on the ballot are actually broken down. Let's go jump to it really quick. Here it is, Trump. Okay, number 1, officer versus office of clause. We're going to go through the ruling from the Supreme Court in a moment. But the officer versus office of clause favored Trump because the president is an office, which favors Trump because the solution would be impeachment, which failed in the Senate, right? To hold office is different from running for office. That it likely favors Trump because the actual, Article 14 of the Constitution, Section 3 of it, disqualifies you from holding, not from running. And so we argued that that favored Trump. States' rights versus federal rights. The Supreme Court made it really clear they were concerned about states having too much power if a state could basically take a candidate off of the ballot. And that, I said, likely favored Trump. We wrote that from a First Amendment point of view, the Colorado Secretary of State, in my opinion, stepped on a landmine, suggesting that being on the ballot is a First Amendment right. I don't know why they said that, but they said that. And I'm like, well, that's a handout to Trump. There was also a powerful quote about democracy. In trying to figure out Section 3, we should think about democracy, the right of the people to let the people decide. Your position as the effect of disenfranchising voters, that was Colorado getting slammed by the court. I said that likely favors Trump. The court argued, hey, why didn't you just file a claim against Donald Trump under Section 2383? That is, anybody who runs is basically disqualified from office if they are an insurrectionist or whatever. Why was Trump not charged under this section? The Supreme Court was asking that. I said that likely favored Trump. Trump's statements, the court did not look at Trump's statements at all when they had their hearing with the Colorado Secretary of State. So I argued that likely favored Trump. And I argued that there's this 1869 Griffin case, which had a lot to do with double jeopardy. If you remove a judge, do you kind of undo all of their prior rulings because they were an insurrectionist in the past or whatever, had to do with confederacies and such? Anyway, we argued that likely favored Trump. So in other words, I tried to be as unbiased as possible, but I'm like, the Supreme Court is probably going to rule in Trump's favor, not because of any bias, from me at least, and how I'm reporting it, just because of the way the Supreme Court talked about it. Now, the Supreme Court could have bias, but that's different. I'm just trying to exclude myself from this, okay? So now, what do we actually have? Well, we have the actual ruling. So we're going to go through the actual ruling together here, and I want to see how this compares to what our prediction was. So I think that's kind of interesting. Okay, ready for this? Section 3 of the 14th. Colorado Supreme Court basically said Trump can't sit on it. Okay, now, because the Constitution makes Congress rather than states, see, there it is. It's federal versus states' rights, right? Federal versus states' rights. That's what the Supreme Court ended up going with here. We reverse the decision, meaning Donald Trump can remain on the ballot. This is a big deal. It happens the day before your Super Tuesday here. Last September, about 6 months before Super Tuesday, 4 Republican, 2 unaffiliated Colorado voters filed a petition against Trump. The voters will be referred to as respondents. Trump's defeat, blah, blah, blah. Okay, we talk about the instruction. Okay, here we go. Here's Section 3 restated. Okay. According to respondents, Section 3 applies to the former president because after taking the presidential oath, he intentionally incited the breaching of the Capitol to retain power. This is sort of a little summary here. They're summarizing that Colorado found that he committed insurrection. In December, the Colorado Supreme Court reversed a ruling basically saying that Donald Trump is going to remain off of the ballot on a 4-3 and basically allowing Donald Trump to remain off of the ballot. then this obviously got pushed up to the Supreme Court. I want to see their ruling. Now we reverse. Okay, now this is where we want to get into the goody details here. Proposed by Congress in 1866 and ratified by the states in the 68, the 14th Amendment expanded federal power at the expense of a state autonomy. This is a big deal. This is a states' rights versus Fed rights case, and thus fundamentally alter the balance of state and federal power. In fact, one of the Supreme Court justices mentioned that the 14th Amendment goes to limit state power, whereas the argument here of the Colorado Supreme Court is actually to broaden state power. Okay. Section 1 of the amendment, for instance, bars the state from depriving any person of life, liberty, or property without due process of the law, or denying any person the equal protection of the law. Section 5 confers Congress the power to enforce these prohibitions. Section 3 of the amendment likewise restricts the state's autonomy, but does so in a different way. So very, very important. So far, everything about this section is how does the Supreme Court, or rather, how does Congress limit the state's power? Okay, so it was designed to help ensure an enduring union by preventing Confederates from returning to power. Okay. It would take yelling secession and hissing copperheads would take seats in the House. Okay. Section 3 aimed to prevent such a resurgence by barring from office those who having once taken an oath to support the Constitution and afterwards rebelled against the government of the United States. This is kind of just going again into the history of the 14th Amendment. Section 3 works by imposing restrictions on certain individuals. That's going to be a big deal, this phrase, certain individuals. Certain individuals matters because they're probably going to make an argument here that the president is not included in those certain individuals. Note that the president is not specifically mentioned in Section 3. Section 3 is actually, I'll just throw it up right here. Look at Section 3 for a moment. No person shall be a senator, representative in Congress, elector of president is not president. Like, the phrase president was specifically excluded from this list, which is very interesting. Anyway, continuing on here. So that's probably the direction the court's going to go here. Let's see. A wide variety or a wide array of offices, rather than by granting rights to all. It is therefore necessary, as Chief Justice Chase concluded, and the Colorado Supreme Court itself recognized, to ascertain what particular individuals are embraced in the provision. This all goes back into some historics here a little bit. I want to see a little bit more of their conclusions, so I'm going to fast forward a little bit. This is a little bit case law here. It is critical when ascertain. Okay, Congress's Section 5 is critical. So they call on Section 5. The relevant provision is Section 5, which enables Congress, subject to the course of judicial review, to pass appropriate legislation to enforce the 14th Amendment. Senator Howard put it at the time that the amendment was framed, Section 5 casts upon Congress the responsibility of seeing to it that all sections of the amendment are carefully carried out. This is, again, the states' rights versus federal rights issue here. Basically arguing Congress has the power over the states. So Congress over states is what we're seeing here. Let's write that down. Congress's Section 5 power is critical when it comes to Section 3. Indeed, during a debate on the enforcement legislation less than a year after its ratification, this is all in the 1800s, Senator Trumbull noted that notwithstanding Section 3, hundreds of men were holding office in violations of the terms, no means for enforcing the disqualification. So basically, they were arguing in Congress, hey, how do we actually enforce Section 3? Congress needs to pass rules to enforce Section 3. And so Senator Trumbull's was basically instrumental in passing the Enforcement Act of 1870. Pursuant to the power conferred by the Section 5 of the 14th Amendment, basically, laws were passed. Okay, got it. The case raised questions about whether states, in addition to Congress, may also enforce Section 3. Here we go. Finally, we're getting court opinion. We conclude that states may disqualify persons from holding office Oh, that's interesting. Or attempting to hold state office. Whoa, that's very interesting. So they say states may prevent individuals from holding a state office, but states have no power to enforce Section 3 with respect to federal offices, especially the presidency. This is actually pretty impressive here. This is a unanimous decision, mind you. Unanimous decision where all justices agree. States do not have this power. So that shows that this is actually pretty nonpartisan here. It's a pretty clear opinion by the court that no, you cannot take away somebody's ability to run for office, for a federal office under or via Section 3. In our federal system, the national government possesses only limited powers. The states, the people retain the remainder. Among those retained powers is the power of the state to order the process of its own governance. That's fine. That would make sense. In particular, states enjoy sovereign power to prescribe the qualifications of their own officers. That's fair. It's basically like, hey, states can determine how their elections are run. They can determine the rules of their election. So let's write that down. States can determine how their elections are run and the rules of their elections. How you doing, Jack? Let's see here. Although the 14th Amendment restricts state power, nothing in it plainly withdraws from the states this traditional authority. Okay, so they're basically saying we're not taking away states' rights. So, not taking away states' rights, but you're certainly not giving the state the right to take away federal rights. Such power over governance, however, does not extend to federal office holders and candidates, because federal officers owe their existence and functions to the united voice of the whole and not a portion of people. That's a big statement right there by the Supreme Court, basically arguing, hey, look, no state has the power to dictate what somebody else in another state can vote for. Think about it. Think about this. This is the way to look at it. Is it fair that someone in I'm just going to make this up, okay? Making this up. California can prevent someone from running for president because California wants them off. Now, the reason I use California in particular is that California has over 10% of the country's population, but it's only 1/50th of states, right? Only 1/50th of states. So this shows you, like, if a state like California, with such a huge potential voting share, can make such an impact on an election, and then say, oh, well, we're going to pick who could be on the ballot or not, then that would give more power to California, right? This would give more power to large states and less power to small states. Remember, the balance between small and large states has been a historically fought. Jack, I'm in the middle of this. Okay, I can't talk to you right now. So unless you want to talk about the Supreme Court.
I was just gonna say bye.
Oh, that you're leaving? All right, I'll give you a big hug. All right, I love you, bro. Okay, thanks, man, for coming by. So this would give more power to large states, and as we know, small states. Remember the compromise we had in history. The compromise in history was senators, each state. Let's write this out. All right, the small state compromise. Senators, small states get 2 senators as well. Big states get representatives based on pop, right? That was a historical compromise. And so the Supreme Court here is trying to preserve the balance between small and big states. Okay, let's keep going here. Nothing in the Constitution delegates to any states any power to enforce Section 3 against federal office holders. Wow, big statement here. As an initial matter, not even the respondents contend that the Constitution authorizes states to somehow remove sitting office holders who may be violating Section 3. That's interesting. So let's say someone is president. Let's say Joe Biden. Okay? Let's say Joe Biden today says, I'm an insurrectionist. I'm an insurrectionist. Okay? Let's say he says that today. Can states remove Biden? And the answer is no. No. Only Congress can through impeachment. And that was tried. Right? Technically, Trump did get impeached. His removal was just never picked up by the Senate. Balance of powers again. Such a power would flout the principle that the Constitution guarantees the entire independence of the general government from any control by individual states. Wow, that's a big line there. Any control of the federal government is not the responsibility of the states, basically. Consistent with that principle, states lack even lesser powers to issue writs of mandamus against federal officials or grant habeas corpus relief to persons in federal custody. Wow. So in other words, if you're in prison, as an example, for a federal crime, let's say, I don't know, international drug smuggling example, then can a state protect you? No. And so they're making the same argument here. Very interesting. States may enforce Section 3 against candidates. See, this is kind of the hold versus run for. States may enforce Section 3 against candidates for federal office. That's what the respondents maintained. But the text of the 14th Amendment on its face does not delegate that power. So in other words, some claim you can stop someone from running for office, but the text does not say that. This is something that we've talked about before. Remember, we talked about that right here on EHAC. We broke this whole summary down. The section does not prohibit the running for office. That was one of the things that we thought would actually favor Trump right here. Okay, very interesting. Let's keep going. I love breaking this kind of stuff down. I think it's so interesting. Okay. This hardly comes as a surprise given the substantive provisions of the amendment embody significant limitations on state authority. Fine. Under this amendment, states cannot abridge privileges or immunities, deprive persons of life, liberty, or property without due process, deny equal protection. On the other hand, the 14th Amendment grants new power to Congress to enforce, but not states, I'm guessing, provisions of the amendment against states. It does not grant states that power. Right. 14th Section 3 gives power by Congress against states, not for states. That's fascinating. Only other plausible constitutional sources of a delegation are elections and electors clauses. Text of the Section 3 reinforces these conclusions. Its final sentence empowers Congress. There it is. There it is. Why did it bounce around? Sorry, 1 second. Okay, what just happened? Hold on. There's little reason to think. Oh, here it is. Its final sentence empowers Congress to remove any Section 3 disability by a 2/3 vote of each house. The text imposes no limits on that power. All right, so let me clarify this. If you're an insurrectionist, you might be disqualified by Congress from holding office, and Congress with two-thirds vote of each chamber allows you to overcome that. And so they're basically saying Congress can solve it. Overcome. Congress can solve, but states cannot solve. So states are basically given no power here in this amendment. Historically, Congress sometimes exercised this amnesty power post-election to ensure that some of its people chosen, to ensure some of the people's chosen candidates could take office. But if states were free to enforce Section 3 by barring candidates from running in the first place, Congress would be forced to exercise its disability removal power before voting. Perhaps a state may burden congressional authority in such a way when it exercises its exclusive sovereign power over its own state offices. Implausible to suppose that the Constitution affirmatively delegated to states the authority to impose such a burden on congressional power. Fine. Let's see. States have no power. Oh, this is a big line. States have no power to retard, impede, or burden in any manner the constitutional laws impacted or built by the Constitution or Congress. Fine. Okay, let's see here. Such a lack of historical precedence is generally telling of a severe constitutional problem. Interesting phrase as well. No precedent. States did disqualify persons from holding state offices following the ratification. So no federal precedent is what they're saying. No federal precedent. However, state precedent exists. And they're saying that because of this lack, this sort of screams constitutional issue. And that's the purpose of the Supreme Court, right? To really evaluate the constitutionality of something. Congress. Instead, it is Congress that has long given to Section 3 with respect to would-be or existing federal office holders. Right, Congress has the power via the Enforcement Act. The act authorized federal district attorneys to bring civil cases to remove any holding office in violation of Section 3. I wonder if this has to do with that section I was talking about, Section 2383, but let's see. Congress has the power. Okay. Confiscation Act effectively provided additional procedure for enforcing qualifications. There it is. There it is. Section 2383. We just predicted that, and there it is. There it is. So the Confiscation Act, which predated Section 3, effectively provided an additional procedure for enforcing disqualification. So the Supreme Court directly challenged this. The Supreme Court directly asked Colorado why they didn't bring charges up via 2383, and Colorado basically punted. Oops. Yeah, the writing was on the wall for this one pretty dang clearly. Okay. Permitting state enforcement of Section 3 against federal office holders and candidates would raise serious questions. Section 5 limits congressional legislation enforcing Section 3 because Section 5 is strictly remedial. Congress must tailor its legislative scheme to remedying or preventing. Fine. Unlike Section 3, unlike the other provisions of the 14th, prescribe the conduct of individuals, bars persons from holding office after taking a qualifying oath and then engaging in insurrection or rebellion. Any congressional legislation enforcing Section 3 must, like the Enforcement Act of 1870, reflect congruence and proportionality. Fine. Neither we nor the respondents are aware of any other legislation by Congress to enforce Section 3. In other words, there is nothing saying states have power to enforce. Okay? So, in other words, the absence of either a precedent or a clear law that allows states to do this does not exist. And Section 5 only gives power to Congress, not to states. Okay. It's worth looking at Section 5 of the 14th. And this is Section 5 of the 14th Amendment vests Congress with the authority to adopt appropriate legislation to enforce other parts of this amendment. Section 5 gives Congress the power to enforce via legislation other parts of this amendment. And that would be the 14th, right? Let's throw that in like this. There we go. As a result, such state enforcement might be argued to sweep more broadly than congressional enforcement under other precedents. But the notion that the Constitution grants states freer reign than Congress is simply implausible. Oh, that's a big line there. Big line. Okay, so big statement here is, aka, the idea that states would have more power than Congress is implausible. Big line. Big line right there. Finally, state enforcement of Section 3 with respect to the presidency would raise heightened concerns. In the context of a presidential election, state-imposed restrictions implicate a uniquely important national interest, but state-by-state resolution of the question whether Section 3 bars a particular candidate for president from serving would be quite unlikely to yield a uniform answer. Right. States might risk applying the law differently, and that provides an ununiform result that affects all voters uniformly. Now think about what I just said there. Applying with an ununiform interpretation a uniform result. Because, in other words, the result in one state affects all states. But each state may have different biases. That makes sense, right? Like, again, imagine if California had the power, and I live in California, right? So, but imagine if California had the power to determine the presidency. That would be highly unfair to a state like, I don't know, Arkansas or Texas or Ohio. Conflicting state outcomes concerning the same candidate could differ from not just differing views of the merits, but from variations of state law. That's also true. Different biases and different procedures, right? The procedures themselves could create issues. The laws. Yeah, and the standards. Different procedures and standards. Some states might use preponderance of the evidence, and others might use a higher standard like reasonable doubt. Right? Remember the difference between a civil case and a criminal case. In a criminal case, you have a standard that somebody must be convicted beyond a reasonable doubt. Whereas in civil cases, you just use a standard known as the preponderance of the evidence. Going to school, bro?
Yeah.
Get over here, bro. Love you, man. Have fun, okay? Go kick butt. Fist bump. Harder. Okay, high five. Harder. Yeah! See you, dude. Some states might allow a Section 3... okay, yeah, we talked about that. Certain evidence might be admissible in some states, but inadmissible in others, like hearsay. Ooh, that's a good one. Differences in evidence. Disqualification might be possible only through criminal prosecution as opposed to expedited civil, particularly in states. Yup. Procedure, okay, the result could well be that a single candidate would be declared ineligible in some states but not in others. Yup. Based on the same conduct. Same conduct could lead to different results. Patchwork would result from states. Patchwork equals non-uniform. Duh. I mean, this is pretty clear cut. Evolving electoral map could dramatically change the behavior of voters. This disruption would be more acute and nullify the votes of millions and change election results. Wow. Oh, after the nation has voted. Yeah. This is double jeopardy. Double jeopardy argument here. Nullifying after the fact. And damage votes previously cast. And this is like so clear cut. Okay. All 9 members of the Supreme Court agreed with the result. Our colleagues writing separately further agree with many of the reasons this opinion provides for reaching it. So far as we can tell, they object only to our taking in account the distinctive way Section 3 works and the fact that Section 5 vests in Congress the power to enforce. These are not the only reasons states lack power to enforce this particular constitutional provision, but they are important ones. And it is the combination of all the reasons set forth in this opinion, not as some of our colleagues would have viewed it, just one particular rationale that resolves this case. In our view, each of these reasons is necessary to provide a complete explanation for the judgment. The mandate shall issue forthwith. It is so ordered. Whoa. That was big. Okay, what else do we have here? These are some more comments here. I agree states lack power. This is Barrett. Amy Coney Barrett. States lack power. What else does she say? The court, politically charged issue. This message, this is the message that Americans should take home. It's true. No political sway there. Here's Sotomayor's. Concurring. Did she have a big banger here at all? In my judgment, not time to amplify disagreement. The court has settled a politically charged issue. Not really. No big banger here. Okay, what do we have here? This is... The court is authorized to say what the law is. Today, the court departs... Wait, what is this? Only because those who apply a rule to particular cases must of necessity expound and interpret the rule. Today, the court departs from that vital principle, deciding not just this case, but challenges that might arise in the future. In this case, the court must decide whether Colorado may keep a presidential candidate off the ballot. Allowing Colorado to do so would create a chaotic state-by-state patchwork at odds with the nation's federalism principles. The majority opines, blah, blah, blah. Okay. We cannot join an opinion that decides momentum. Okay, what? In doing so, the majority... What is Sotomayor saying here? So today, the court departs from the... Okay. But challenges that might arise. In this case, the court must decide whether Colorado may keep a presidential candidate off the ballot. Right? Allowing Colorado to do so, we agree, would create a chaotic patchwork. We got that. Yet the majority goes further. Even though all 9 members of the court agree that this resolves the case, 5 justices go on. They decide novel constitutional questions to insulate this court and the petitioner from future controversy. Although only an individual state's action is at issue here, the majority opines on which federal actors can enforce Section 3 and how they must do so. The majority announces that a disqualification from insurrection can occur only when Congress enacts a particular kind of legislation to pursue the 14th Amendment. In doing so, the majority shuts the door on other potential means of enforcement. We cannot join an opinion that decides momentum. Okay, so Sotomayor here is actually countering. She's like, hey, I agree states should not decide, but I disagree that the only way to disqualify is by Congress enacting legislation. So here's where you're getting that 5-4 split. Here's that 5-4 split. So there is some split here. Okay. Federalism principles embedded in the constitutional structure decide this case. States cannot use their control over the ballot to undermine the national government. Yes. Then danger is even greater. State restrictions in the context. Whatever. No doubt, states have significant authority over presidential electors. That's fine. The electors part we know. This is the electors versus actual president. Electors of president argument. Okay, the majority rests on such principles when it explains why Colorado cannot take a petitioner off the ballot. Quite unlikely to yield a uniform. That's fine. Okay. Disqualifying a candidate for office wouldn't work. Yet the court continues on to resolve questions not before us. In a case involving no federal action whatsoever, the court opines on how federal enforcement of Section 3 must proceed. Congress, the majority says, must enact legislation. Right. So this is Sotomayor's beef. Sotomayor argues like, hey, we shouldn't go that far. Nothing else in the 14th Amendment supports the majority's view. Section 5 gives power to enforce by appropriate legislation. Remedial, however, legislation is not required. Okay, so Sotomayor saying, hey, we don't need legislation for remedial disqualifications. That's too much of a burden. So kind of just arguing that, hey, this goes a little further than we should be going. Just like, that's an interesting one. Implementing the two-term limit. I mean, that's a good counter argument. The two-term presidential limit does not require implementing legislation. You just follow the requirement as written in Constitution. Okay. Let me see here. That was the 22nd Amendment. Via 22nd Amendment. I had to look up really quick which amendment the term limit. Oh, it says it right there. There it is right there. I could have just read one more sentence. 22nd Amendment. Term limits. Right there. Okay. All right. So I kind of got Sotomayor's argument here. What it does today, the court should have left undone. Okay. What does Jackson... Okay, now we've got Jackson and Sotomayor. So they wrote this together. The court reaches a question not before us. That's fine. This is the same thing. Okay, cool. Should we do a summary? Obviously, this is big news here from the Supreme Court. I think we should probably do a little summary, but this is a pretty big moment. So I think maybe if we slap together like an 8-minute summary here, we can get a little bit of a breakdown. Okay, let's do that really quick. Well, the Supreme Court just decided that Donald Trump can indeed remain on the ballot. I'm going to go through some of the core pieces of what the Supreme Court in their unanimous decision said, and I'm also going to show you where there was, well, let's just say there were some justices that were a little PO'd at how far the court went in this case. First, on ehack.com, I wrote down some items where I thought and predicted that Donald Trump would probably win this Supreme Court case. And one of those had to do with officer versus office of. This just has to do with the distinction between the fact that can you run for office or as a candidate, or can you, or is the Section 3 of the 14th prevent you from holding office? And really the court agreed that as an office, you have to resort to impeachment to prevent somebody from being in that office. And there's nothing in the 14th that says you can prevent somebody from running for office. We're going to see that in the actual court documents. Remember, Section 3 does specify elector of president, but it never actually talks about the office of president. It really gives Congress that right. A lot of this case has to do, as predicted, with states versus federal rights. There was no talk about the First Amendment really in this, so we left the First Amendment out of this in the actual decision. The disenfranchising voters concern did come up in the case. Section 2383 did come up in the case. Trump's statements did not come up in the case, and double jeopardy did come up in the case. So a lot of what we kind of predicted this case on did come up in the actual ruling, and I want to highlight some of the most important components of this. So the most important components really come in here. The Supreme Court decides that states may disqualify people from holding a state office, But they say that states don't actually have the power to determine whether a federal candidate can be on a federal ballot because it would create too much of a patchwork of results. We'll get into how they break that down in a moment. But first, they make it very clear. Look, states, you can decide how state elections are run, and you can decide the rules for state elections, but you don't have the power to decide how federal elections are run. And this really goes back to small states versus big states and federalism arguments. Remember, small states got the benefit of having senators. Every state gets 2 senators. Big states, through compromise, got the benefit of having representatives through the power of how much of a population you have. That was a historical compromise. And the Supreme Court argues, look, let's just say that, Joe Biden today self-declares he's an insurrectionist. Would states have the power to actually remove Joe Biden? The answer is no. Only Congress can do that through impeachment. And remember, Donald Trump was already impeached, but he was not fully removed by the Senate, impeached in the House, not removed by the Senate. They also argue, if you're in prison for a federal crime, can a state protect you? And the answer is no, a state cannot. They also make it clear that you can't stop somebody from running for office. That people might claim that, but there's nothing in the 14th Amendment that says somebody cannot run for office. This is something we talked on over here at EHAC as it really breaks down. The prevention of Section 3 is preventing somebody from holding office, not running for office. Remember, ehack.com. I'll throw up the actual annotated text in a moment on ehack.com so you can get my whole breakdown here of the ruling. And I throw all my research up on that website just sort of as a free compilation. But anyway, Congress has the power to remove any disqualification. Like, let's say you're an insurrectionist. Let's make it very clear. You're an insurrectionist and you want to run for office. Can you? Yes. If Congress, through a 2/3 vote, says you can. But otherwise, states don't have the power to say, no, it's okay, you can. And that becomes very important in this ruling. States have no power to retard, impede, burden, or in any manner control the operations of constitutional laws. There's no federal precedent. There is state precedent, but the lack of federal precedent screams that this is a constitutional issue at heart. And the Supreme Court rules on constitutional issues. The Supreme Court then directly asked Colorado, why did you not bring up a case against Trump under Section 2383, which would disqualify the president, or really anybody, through an insurrection claim? And the Supreme Court decided not to use, the state Supreme Court or the state of Colorado itself decided not to use 2383. They punted why they didn't use 2383. Supreme Court didn't like that of the United States. Said we already have rules that exist that you could use, and now you're trying to create new rules. Doesn't work that way. The Supreme Court is not aware of any legislation that exists to enforce Section 3, and there's nothing explicitly that says states have any power. In fact, Section 5 of the 14th Amendment gives power specifically to Congress, and the whole 14th Amendment is designed to limit the power of states. So the 14th Amendment limits the power of states and gives more power to Congress. So why would the Supreme Court here interpret that the state should have more power than Congress? They see that as implausible. In fact, they specifically say the idea that states would have more power than Congress is implausible via this section. They also argue that there are risks that states might apply the law differently, not because just maybe like some states are going to be biased. Like obviously there's going to be a difference in bias between like a California and an Arkansas, but also that different states might have different procedures and standards. Some states might require the preponderance of evidence, which is what we use in civil trials, whereas others might use the reasonable doubt standard, which is what we use in criminal cases. Since there's no standard here, you would end up with likely a patchwork or non-uniform result of who could run for office. And you'd basically have a bunch of different states putting different people on the ballot. It'd be a complete disaster. In addition to that, we get the double jeopardy argument that if someone was allowed to remove someone from the ballot in one state, then let's say that person becomes president, it's entirely possible the state could try to undo that presidential seating, and therefore all of the work that president does could come into question. That'd be a big problem. Now, all 9 members agreed with this. It was so ordered. This was a unanimous decision. However, the opinions were not unanimous. We did have Amy Coney Barrett provide a majority opinion. This was 5-4 split, not in the actual decision, but in how the opinion was written. So 5 justices supported the ruling as they made it. However, 4 of them, led by Sotomayor and Jackson, argued that, yes, states do not have the power to remove somebody from the ballot. However, they went as far as saying you should not have an argument by the Supreme Court that says, hey, look, only Congress has the power to enact the Section 3 terms. They're basically arguing, hey, you know what? Look, you know how there's a rule that says you can only have a president who served for 2 terms, and after that, the president can't run anymore? That's in the 22nd Amendment. We don't have an extra law or case law that says, okay, once you're past 2 terms, you can't. It's just enshrined in the Constitution. And so the minority here is a little peeved that the Supreme Court maybe went a little too far maybe to the right, to argue that this Section 3 is so steadfastly clear that states have no power. So if I were to just simplify this, let me make this very, very simple. I would say 9 out of 9 justices said states cannot remove people from ballots. All right, people from Fed ballots. Okay, that was 9 out of 9. However, 5 out of 4 said that states have no power via the 3rd. And 4 out of 9, there we go. 4 out of 9 said, whoa, don't go that far. So they're kind of just like preserving a little bit of like a hole there in the longer term future. So that's it. That is basically what just happened here. So, I mean, I think this was pretty obvious, but I mean, yes, as predicted, Donald Trump won this. You could say that in an unbiased manner because the Supreme Court, if you listen to the hearing, there was no way you could have looked at that hearing and said, oh yeah, Colorado's good. They've got a chance. They really didn't. I've talked about that on the channel numerous times. So anyway, that's my summary. Thank you so much for watching. And folks, we'll see you in the next one. Goodbye and good luck.